What is a 402 conference? That's the subject of today's Need to Know. Need to know what? Need to know the law. Dave McDermott here, McDermott Law Group, McDermott Mafia, McDermott Militia, all one and the same. 402 conference really only applies to Illinois cases. The reason it applies to Illinois cases is because it is pursuant to Supreme Court Rule 402. Shocker, huh? Anyway, 402 conference is when the defense attorney requests, because the defense attorney has to be the one requesting it, that she go back into the judge's chambers. It's typically in chambers. Go back in judge's chambers with the prosecutor and talk to the judge about the case in an effort to try to see if it can be resolved. So what does that mean? And by the way, something you have to know, the state's attorney, the prosecutor has to agree to the 402 conference, otherwise it does not happen. So what happens when you go back for a 402 conference, the defense attorney, the prosecutor, and the judge sit down, and the judge gets to hear certain things that the judge would not otherwise hear unless the case were to go to trial. So the judge has to do what's called admonish the defendant, which means warn the defendant, hey, guess what, John Doe, if I listen to this 402 conference, if I preside over this 402 conference, if it takes place and I hear different things about this case, you can't go ahead and request a different judge now that I've heard this. So in all probability, I'll still be the one hearing your case in the event that it goes forward to trial. And why is this significant? Because at 402 conference, the state's attorney is going to go ahead and tell the judge everything the state's attorney believes is in any way relevant to the case. So the state's attorney is going to say, hey, John did this, and then John did this, and then John did this, and then John supposedly did this and this and this as well. And the defense attorney is probably going to go ahead and spend some time saying, well, you know what, that's the state's position. Either no, my client didn't do this, or my client, the state is entitled to its position. We have our own position as well. But really the main reason for a 402 conference is, again, seeing if the case can be resolved. So what you're doing in a sense is you're basically presenting the judge with different mitigating factors, saying, hey, John Doe's actually a good guy. John Doe has this going for him, that going for him. He's out there in the community doing positive things for the community, so on and so forth. Just going ahead and giving the judge a bunch of mitigating factors. And then you ask the judge to go ahead and give a recommendation at that time. So it's called a 402 recommendation, at which point the judge says, based on what the state is saying and based on what the defense is saying about, certain issues maybe with the evidence or certain issues with the case, or just basically, hey, John Doe is a pretty good person based on what the defense is saying for the following reasons, I'm willing to go ahead and sentence John Doe to this. So for example, say it's a case that carries jail time, but it's also probation eligible. The judge can say, okay, based on what I just heard, I'm not going to go ahead and send this guy to jail. Instead, I'm going to go ahead and give him probation if he takes this 402 recommendation. Then you go back to your client as a defense attorney. You tell your client what the 402 recommendation is, what the judge's recommendation is for resolving the case. If your client takes it, your client can go ahead and take it, go forward with the plea, and resolve the case then and there, or maybe on the next court date. If your client rejects it, just so you understand, then your client has the ability to reject it, and you can instead proceed with hearings on motions or proceed to a trial on the case. That's basically what a 402 conference is. Until next time, talk to you soon.